want to bring my fellow senators up to date on a subject that was sparked by the remarks made this morning by the minority leader. And I also want to add some additional context that the minority leader left out. He spoke on the nomination of Judge Kavanaugh to the Supreme Court. Unfortunately, he didn't come to the floor to talk about the judge's excellent qualifications, the judge's well-regarded temperament, or the judge's judicial philosophy. He didn't come to the floor to announce that he would finally extend the courtesy of a meeting to the judge, which is customary in this body. He came to speak about what he thinks will satisfy left-wing outside groups. He demands that I sign a letter that would put the American taxpayers on the hook for a Democratic fishing expedition, and I'm not going to do that. Now, I agree that we should have a thorough vetting process for the nominee, and we will, and that we should review materials that will reveal Judge Kavanaugh's legal thinking. That's our job. We're not going to be a rubber stamp. Fortunately for us, we have immediate access to the most valuable documents that are out there that reveal Judge Kavanaugh's legal thinking. We have access to more than 300 opinions Judge Kavanaugh authored in his 12 years on the D.C. Circuit, as well as hundreds more opinions that he joined. In these opinions, he addressed some of the most significant legal issues of the past decade from the second most powerful court in the land. This morning, the minority leader brought up a statement that I made in 2010 in connection with Justice Kagan's Supreme Court nomination. At that time, this senator was interested in reviewing documents from her time in the Clinton administration. What the minority leader neglects to mention is, unlike Judge Kavanaugh, Justice Kagan hadn't served as a judge before being nominated to the Supreme Court. Besides her federal government service, at the time she was nominated, she was dean of a law school. Other than Kagan's materials that she submitted as part of the Senate Judiciary questionnaire for her nomination, her White House counsel's office and domestic policy council documents were some of the few categories of documents that could shed light on her legal thinking, since she didn't have any judicial writings, meaning as a judge. Justice Kagan had written or joined a grand total of 0 judicial opinions before her nomination. For us in the Senate Judiciary Committee to carry out our constitutional advice and consent responsibilities as senators, we needed to better understand her legal thinking and potential jurisdiction. Now, Judge Kavanaugh, by contrast, has authored over 300 judicial opinions in his 12 years on the bench. That's over 300. That doesn't include the hundreds of other decisions where he joined an opinion or some sort of order. When you add those to the mix, that's thousands of pages of judicial writing that the American people have access to at this exact moment. You don't have to wait to get this information about Judge Kavanaugh. Now, to the contrary, Justice Kagan, of course, had 0 pages of judicial opinions. That is in addition or this is in addition to the 6,168 pages of records Judge Kavanaugh included in his response to the Senate Judiciary Questionnaire, which we put on the website last weekend. It's for the whole public to view if they want to know everything about Judge Kavanaugh as a judge and things that that he spoke and wrote documents about other than just judicial opinions. Now, despite the fact that Judge Kavanaugh's judicial record is much more substantial than Justice Kagan's was, I agree that we should still ask the White House for documents pertaining to Judge Kavanaugh's time in the White House counsel's office. My Democratic colleagues say that they want the White House records. Well, I'm pleased to let them know that in the coming weeks, the Senate will receive what will likely be the largest document production in history for a Supreme Court nomination. I expect that the Senate could receive up to 1 million pages of documents related to Judge Kavanaugh's time in the White House counsel's office. We will also see the White House nomination files for Judge Kavanaugh's 2006 nomination to the D.C. Circuit, where, as I've told you, he now sits, but also along with records from Judge Kavanaugh's time in the Office of Independent Counsel. By comparison, we received less than 180,000 pages for Justice Kagan's time in 2 White House offices. So let's recap. We have more than 300 of Judge Kavanaugh's actual judicial opinions to Justice Kagan's 0. We could have up to 5 times as many pages for his time in the White House than we got for Justice Kagan. And we will have those documents despite the fact that they're less necessary now than they were for Justice Kagan. In short, then, there will be much more transparency in this Supreme Court nomination process than ever before. Now, I'm ready to send a letter to the National Archives requesting relevant White House counsel documents. I'd like to do this with the ranking member, but unfortunately she has declined this request. This is unfortunate. Both sides agree the White House counsel documents are relevant. I'd like to get them over here as quickly as possible so we can begin reviewing them. But as I noted, the Democratic leadership has already decided to oppose Judge Kavanaugh's confirmation. They'd like to slow down the process as much as possible. I think that explains why the ranking member won't sign a letter requesting documents that both sides want. I've heard that some of my Democratic colleagues would like to request all of Judge Kavanaugh's records from his time as White House staff secretary. But these documents are both the least relevant to Judge Kavanaugh's legal thinking and the most sensitive to the executive branch. The staff secretary is the inbox and outbox of the Oval Office. Passing through the staff secretary's office are a wide range of communications requesting things like flying the flag at half-mast to somehow including daily lunch menus, to draft speeches, to sensitive national security papers. The staff secretary's primary charge is not to provide his own substantive work product. The staff secretary makes sure that the president sees memos and policy papers produced by other offices in the White House. It's a very important job. It requires someone who is smart, someone who's hardworking, and someone who's talented. But the documents passing through Judge Kavanaugh's office while he was staff secretary are not particularly relevant to his legal thinking and for consideration of whether he should be on the Supreme Court. It's like saying, in a sense, the Senate clerk, someone who has a very difficult and demanding job, is responsible for all the positions taken by each of the Senate offices. It's absurd. The Senate should focus its efforts on reviewing his tens of thousands of pages of judicial opinions and other legal writings. Not only would a broad review of staff secretary documents be a waste of time, but also a waste of taxpayers' money. Moreover, staff secretary documents contain some of the most sensitive information and sensitive advice that went directly to President Bush from a range of policy advisors. Back in 2010, both Democrats and Republicans agreed that Justice Kagan shouldn't produce internal communications while she was Solicitor General because of those documents' sensitivity. If we're going to talk about a Kagan standard, then we need to talk about taking sensitive communications off the table. That's what all sides agreed to in 2010 and what I'll insist on now. So I appreciate the minority leader's efforts to ensure some transparency and thoroughness, but let's get right down to brass tacks. I don't think the minority leader actually wants to read millions of pages that crossed Judge Kavanaugh's desk way back in 2004 and probably the 3 years that he held that position of secretary. The minority leader said he'd fight this nomination with everything he's got. And this proved what I've been talking about, and his request proves that he's willing to do that, because this bloated document request is part of that fight. This is not about anything other than obstruction. To bury us in millions and millions of pages of paper so we cannot have a confirmation vote on Judge Kavanaugh this year. Liberal, dark money, outside groups want to drag this confirmation out just as far as they can to the end of time. I won't let them. This confirmation process should focus on Judge Kavanaugh's qualifications, not become a taxpayer-funded fishing expedition. I yield the floor.